Thank you.
Justice Jackson?
So I guess I'm still not clear why the onus isn't on the government official to be clear about the capacity in which they're operating. I mean, I take your point that you can have an individual who's a public official and they can operate in both worlds, official and also personal. But to the extent that we're having a problem, or at least I'm having a problem, it's because we can't identify whether this particular action is occurring in one world rather than the other. And we've said in lines of cases like the Pickering line of cases, we've recognized that even though public employees have a First Amendment right to speak, they can be limited in that ability to speak. So it doesn't seem responsive to me, at least, for you to say, well, they have a First Amendment right, so they bear no responsibility in making clear as to when they are operating personally versus officially. So can you just say more about that?
Sure, I'll try. I'll say three things. So the first is, again, the conduct that they're objecting to is the blocking. Right. This is not a case where they're complaining because they were confused, that they thought it was official, and if they had known it was official, something else would have happened. Everything in this case would have been exactly the same if that page was plastered with disclaimers.
Yeah, but it's not, no, I guess what I'm trying to understand is when we isolate the blocking, and you're right, that is the claim, we have to think about, as Justice Kagan pointed out, the implications of that on the First Amendment rights of the people who want to see the page. So what's happening is they're being blocked from either commenting or seeing the information that's being posted on this particular page. And when the official says, but that particular page is my private page and I'm operating in a private capacity, then I suppose we have one set of answers. But if we believe that that page is actually operating as the official government page and the person is being blocked, we might have a different set of answers. So the question is, with respect to the blocking, is it happening in a personal or an official capacity, and why wouldn't it be the public official's responsibility to say, if you're on this page and you're either seeing or not seeing things, understand this is a personal repository of information?
Right. So, again, I guess what I would say, Your Honor, is if you concede that my clients could have done this in their personal capacity with disclaimers, the question is where in the Constitution are they obligated to put up the disclaimer if they want to maintain those rights?
If they want us to believe that they're doing it in their personal, I mean, well, how else are we supposed to know? Well, I mean, that's just one set of questions.
To be fair, they've got the burden of proof. They're the plaintiffs in this case. They're the ones who are arguing it's state action. So the burden should be on them to show the opposite, not on my clients to disprove it. The second point I would...
So you're saying that a public official can just make a decision sub silentio about which world they're operating in, not let anybody know, and it would be the burden on whoever is saying that you are violating my constitutional rights to determine that you were actually operating in the official capacity.
In a case like this where there's no objective indicia that they were doing it in their governmental role, there's no staffing, there's no resources, there's no control.
What about the page, the way it looks, the way, this is the other argument,
Everything
right?
about this page's appearance is equally consistent with a campaign page. That's exactly what happened in the Eighth Circuit. A page that looked no different than our page, the judges just split, saying,
Okay.
well...
Can I just ask one more question? I'm sorry. Justice Sotomayor came up with a private hotline example to seek emergency help that I thought was really interesting. I hadn't thought of it before. And I understood you to say that the response, the government rushes to your house as a result of getting the communication, would be official action. But I guess I'm not clear as to the blocking that would occur by the official from people that they didn't like with respect to a page that was designated as, this is the opportunity to call for government help. I'm creating this Facebook page so that people can have a straight-through hotline to government resources. The person, I guess, is saying this is a private page so I can block, Latinos. I don't want any Latinos on this page, says the person. Is that a problem? Or, I mean, is that state action or not state action?
I would think if that's all there is, I would say it's not, because a private citizen could set up that exact same page. This is a page to get you access to government.
But if they did, wouldn't that implicate all of the lines of cases where we talk about or we think about whether or not a private citizen is actually acting in a way that's fairly attributable to the state? I mean, we don't just stop at saying, oh, a private citizen.
I don't think any of those tests would be met.
The one about joint action between the private party and the state, the Brentwood Academy line, where you're looking at, is this facilitating a state service, you think would not apply?
I don't think, again, if a purely private citizen, just think, a wealthy person in the city said, I want to make it more easy for people to call and get access to government things, and sets up a page like that. That's not joint action. He's acting wholly independent of the government.
All right, thank you.